Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome everyone to a series of podcasts that Hall & Wilcox and the Health and Community Group at Hall & Wilcox are bringing to everyone on the aged care sector. My name is Carl Rosenbergs and I'm the co-head of the Health and Care Group at Hall & Wilcox, and I've been joined by my fellow partner Anthony Brediker and Special Counsel Claire Curley. Today, we're focusing on employment and taxation issues facing the aged care sector. So I think, we can all agree that there's been a huge amount of reform in employment law over the last 2 years. And I'll turn to Claire now and ask her, what do you think are the recent developments in the aged care sector regarding employment law that people should know about, especially boards?
Thanks, Carl. Yeah, look, as you know, it's been a massive sort of 12 to 18 months of really serious change in employment law and things that will have ramifications and implications, particularly in the aged care sector. Look, I think underpayments are still a hot topic. As wage theft, as they're known. Last year, the Fair Work Ombudsman recovered $509 million from underpaid workers. So we're talking big bucks here, and it's the second largest annual figure the Ombudsman's ever recorded. And what's really surprising is this underpayment is not from sort of smaller businesses. Over 50% of the errors came from large corporate organisations like unis and aged care providers and things like that, who also have large HR, payroll and compliance teams. So it's really important to note that this thing isn't sort of something that happens to smaller businesses. It can and does happen to big businesses, and the implications were very serious and are now even more serious. The changes under the Fair Work Act to civil penalties and serious contraventions started on the 27th of Feb this year. And what the new laws do is increase the maximum penalties that courts can impose for certain contraventions, as well as introducing a new threshold for what a serious contravention is. So they've doubled the maximum penalties for non-compliance with a compliance notice and increased the maximum penalty by 5 times for businesses with 15 or more employees. And as you know, Carl, the big change also is that a serious contravention, the threshold of what that is, has completely changed. So it used to be, and the previous threshold used to be that a knowing and systematic contravention, and now it's a knowing or reckless contravention.
But just with that change in the definition, I mean, that's going to have serious implications for how people deal with underpayments. My question to you is, will that require audits, more auditing?
Yeah, I think it requires more scrutiny on payroll and more audits. Correct, that's right. As you know, on July the 1st every year, our bond award wages go up, and usually under an enterprise agreement, the wages go up as well. And every year you need to be making sure that what you're paying these people, whether it be salary or on an hourly wage basis, is accurate, is correct. All allowances are captured. Everything comes out in the wash. And the only way you're going to do that is with regular auditing and actually doing the maths. Wages, as you know, is not a set and forget exercise. You have to keep checking up routinely, at least yearly, and preferably more often than that.
Yeah, and the same could be said because, I mean, we deal with a lot of bargaining with enterprise agreements and changes to enterprise agreements. And, often in my experience, the problem lies in payroll and the people who are doing the negotiating, once they're finalised the enterprise agreement, not talking to each other, and that's where errors can creep in. And so that's another reason why, because a lot of aged care is covered by enterprise agreements. Do you agree with that premise?
Absolutely, Carl. I think that payroll is not just a back office admin task. It's a highly sophisticated function these days because of the complexity of employment law, and employers need to invest in that function. So it needs to have a highly sophisticated HR and payroll function. It's not a part-time bookkeeper's job. It is a really difficult job where when you get it wrong, the consequences can be dire.
Yeah, it's definitely not a set and forget, like you said before. And what other issues do you think come into play, Anthony? On the underpayments, what have you seen the tax issues and consequences stemming from underpayments in your experience?
Yeah, thanks, Carl. So I think, look, Claire's sort of identified one of the key issues that obviously impacts employers and employees, and we can't forget about the fact that obviously the key important thing here is to make sure that employees get their full employment entitlements and pay and salary and so on. But the remediation of underpayments also has an on-cost impact. So if, for example, the employer has underpaid salary or wages, they're almost certainly going to have underpaid their superannuation as well for those employees. And unfortunately, rectification of superannuation can be very expensive. And that's because, there's no time limit on how far back unpaid super needs to be paid back for. Practically it can be 5 years, but look, quite possibly the ATO may well decide that you've got to go back to the date when the superannuation law was introduced back in 1992. The other aspect is penalties. So not only do you have to go back potentially a long time, but you could also be subject to penalties. And if an employer underpays super, the penalties can be up to 200% of the unpaid super. So it's a very significant impost here. And importantly, also the catch-up payments for super aren't deductible. And obviously these costs can add up. So as an employer, if you've underpaid super, you should be getting on the front foot. You need to work out what your underpayments are and make good on those underpayments. And you can do this by going through the ATO as well, because the ATO administers superannuation, and provided you get on the front foot and come to them first and disclose to them and admit that you've made an underpayment and you're trying to rectify things, it's usually the case that you can avoid that 200% penalty, which is obviously very, very significant.
Just with the time, you said 1993, right? Can you try, if you were to self-report to the ATO, is there any way you can negotiate a shorter period?
Yeah, absolutely. So if you come forward to the ATO, from an administrative perspective, the ATO can shorten the period to which you're subject to those penalties. And the ATO's policy has been that if you administratively come to them first, before you're under any kind of audit or any kind of review, and you fess up, you put your hand up and say, look, we've underpaid our super. Typically, the ATO, if you've otherwise got a good compliance history, will typically allow you to only to limit how far back you go to just the 4 or 5 years. If, however, you're unfortunately a taxpayer that maybe doesn't have a great compliance history, the ATO may well expect you to go back a bit further. But if you get to and get on the front foot, you can usually cap that the back payment period to 4 or 5 years.
Have you had that's great advice, Anthony. But have you had experience where annual leave loading has been an issue, the payment of super on annual leave loading, in terms of whether super is payable or not, and how that interrelates with the interpretation of enterprise agreements? That's an area that I came across, and I think it's a sleeping. It's something that's just a lot of people might not appreciate that it's something that could come up.
Yeah, sure, Carl. It's a good question. I don't want to be unnecessarily alarmist here, but most clients do, generally speaking, get super right. Obviously, putting aside the underpayments question, most clients do get super right. They're generally well organised and well advised, but sometimes the gaps do occur on the edges. Now, one example of this can be, people in payroll are generally aware that you pay super on salary and wages, but not on overtime. The super position's usually quite binary in most cases. Super will be payable or it won't be payable. But leave loading, the example you gave there, is one exception to that rule, where the answer is, on leave loading, superannuation may well be payable, but the answer is it depends. Generally speaking, you do have to pay super on leave loading, so that should always be the default position, unless you can show that the leave loading is paid for the loss of the ability to work overtime. Now, we've actually had a few clients caught by this, the nuance regarding leave loading, and one client with a workforce of a few thousand workers who generally had their superannuation sorted, but they actually thought they didn't have to pay superannuation on leave loading, so they didn't pay it. They didn't investigate. And unfortunately for them, look, they identified the problem after a few years. They still had to remediate and back pay super back 4 years because we did a voluntary disclosure. But with superannuation and the admin charge and interest, we've managed to cap their liability at about $400,000 by making a voluntary disclosure for them. But we're pretty confident that we've escaped penalties on that front. And had we not, on their behalf, approached the ATO, the penalties and the cost of super could well have been well in excess of $1 million.
Yeah, sounds like getting on the front foot really worked well. I mean, it's a terrible situation to be in, and it's one of those things that you might have the best intentions, but it's just the way that the enterprise agreement could be drafted, and people haven't turned their mind to this particular issue, and that could cause a problem going forward. Turning to Claire, just what other reforms and issues should employers in the aged care sector be aware of?
Another one is the newly introduced positive duty to prevent sexual harassment in the workplace. Now, we've moved from, although having a positive duty to keep your workers safe has always been the case in work health safety law, as we all know, this is now explicit in both the Sex Discrimination Act, so the Federal Sex Discrimination Act, and the Fair Work Act. And what it requires is for organisations and businesses to eliminate as far as possible discrimination on the grounds of sex, sexual harassment in connection with work, sex-based harassment in connection with work, so they're two different things, conduct creating a workplace environment that's hostile on the grounds of sex, and all related acts of victimisation. So you've got a long laundry list of stuff you have to positively prevent from happening. And so it's really important for employers to understand that no longer can you react to a complaint of sexual harassment. I mean, you do when it does happen, but of course you must have preventative steps in place to stop it happening in the first place, and that's now a legal and explicit legal obligation. So employers need to be taking positive and proactive steps and thinking about, what does my organisation do to protect my workers from this list of behaviours which are unlawful. So if employers have not yet turned their mind to this, they should be, and they should be thinking about incidences or issues of sex-based harassment or sexual harassment in the workplace that they've received complaints about, and looking at how they can prevent that from ever happening again.
So you that's it places a big burden on HR these days. HR has to become they're sophisticated, but even more sophisticated and proactive to deal with this positive duty. I mean, what kind of steps are you recommending that they take in terms of, really checking out whether something's happening at a particular, say, facility in the aged care sector, and that you've got a problem? I mean, what do you do? Surveys or something like that?
Yeah, look, that's a fantastic idea, Carl. So above and beyond sort of your baseline compliance stuff, like you must have policies and procedures in place. People must know how to report the issues, and they must all be trained in them. So again, not a set and forget. We don't put our policies and procedures into a box in the back office and forget about them. We need to be proactively training our workforce on them. But as you say, a good way of discovering, hey, is there an underlying issue in my workplace that perhaps I haven't heard about, is anonymous surveys of your workforce. So quite frequently, large organisations do engagement surveys. Think about doing surveys, and anonymous is better in this circumstance because people are more likely to report, given the sensitivities around the sort of behaviour. Sure. That you do a survey and say, do you feel safe in the workplace? Do you feel discriminated on account of your gender? And we're talking about a workforce with a really high proportion of female workers. So it is really important in this industry because it is likely to become an issue or more likely than some other organisations.
So this is different to the psychosocial reforms. Just want to have a clear distinction between what this positive duty to abolish sexual harassment and the psychosocial reforms. I mean, can you maybe explain to our listeners how that's different?
Sure, they're overlapping. They are different laws, but they are overlapping issues. So there is, under work health safety legislation, an obligation to keep our workforce psychosocially safe, to keep their psychological welfare free from risks and hazards in the workplace. Again, that's always been the law. It's just now more explicit. So we could always we always had to protect people from psychological injury, and now we've got a code of conduct telling us how to do it effectively. Sexual harassment in the workplace is a psychosocial risk, but also it is a standalone issue that via organisations like Respect at Work and the sort of seminal report done by Kate Jenkins, the Sex Discrimination Commissioner, we understand how prevalent and how present it is in modern workplaces. And so this is why there's this separate sort of set of laws under the Sex Discrimination Act and under the Fair Work Act saying you must prevent this from happening in the first place, just like you must prevent someone from falling off a piece of scaffolding or falling off a ladder. You must prevent them being sexually harassed in the workplace, and that's part of keeping them safe from a psychosocial perspective.
Yeah, so you could imagine that psychosocial covers things not covered by the positive duty to abolish sexual harassment, so like bullying in the workplace.
Correct.
But it's not. It's like when a machine breaks down, you fix it, or if it needs a guard, you put a guard on it. I mean, this is all dealing with people, and that's why it's so difficult. So if you've got, say, you see that there is a potential for a risk in the workforce at a facility, I mean, what do you do? You can't just fix the machine or put a guard on it. What does it lead to? Would you need to be able to show if if the regulator came and knocking that you'd given warnings and you'd done everything you could to try and prevent it?
Yeah, it's a really good question, because as you say, Carl, when we're dealing with people, things aren't black and white. They can't be fixed with a guard. So it is more grey than that. What we need to do is, as I said, comply with our own policies and procedures and make sure they're promulgated throughout the workplace so people understand and know what to do, and that the very highest level of your workplace leads by example, sets that example, and actively enforces these policies and procedures. So if you do hear about sexual harassment or discrimination based on the grounds of sex in your workplace, you act quickly, you act appropriately, you take action. You must remember there's no such thing as a confidential complaint. Once you're on notice about it, you're on notice about it. The fact that it's confidential doesn't stop that person applying to a court at some point in the future for a remedy. So you need to act on it as soon as you become aware of it, and preferably you've taken your steps to stop it happening in the first place. But of course, hindsight is always 20/20. So if it has happened in your workplace, you are then armed with how did this happen and how do I stop it happening again? But I would say
what do we do about it?
Exactly. Swift and decisive action, I think, is really important in this. You show the rest of your workforce we take this really seriously, as we're obliged to do, and we act appropriately when it does happen. So it's about investigating matters and complaints and taking appropriate action. Sexual harassment has been added to the list of what constitutes serious misconduct in the Fair Work Act. So that's a signal from the Fair Work Commission saying, hey, if you want to end this person's employment, you may be permitted, provided you follow all the other rules around terminating someone's employment. This is serious enough to do that.
Yeah, there's there's so many things to take into account and to prepare for going forward, given all the reforms. And one other one I'd like to touch on is the same job, same pay reforms. If we just talk about that very briefly and what ramifications that might have in the aged care space.
Sure. So lots of aged care organisations and businesses use agency labour to supplement their own in-house labour. So that's usually via a hire agency. What the Same Job, Same Pay framework did was it empowers the Fair Work Commission to order labour hire workers engaged by a host company, so engaged by the aged care facility, to receive the same pay as the company's employees, if certain requirements are met. So at the moment, we're sort of a little bit in the dark as to how this will operate, but the first application has been made to the Fair Work Commission by the Mining and Energy Union. And so we're hoping this is going to provide us with useful guidance on how it works. But what in that matter, so it's a WorkPac matter, the union seeking orders that labour hire workers employed by WorkPac are paid the same as employees hosted by the host employer Batch Fire Resources under an enterprise agreement. Now, any regulated labour hire order made by the Fair Work Commission doesn't take effect until the 1st of November 2024, but the provisions are in place now. So people are able to apply now. So if you do have an enterprise agreement in place and you do have a high proportion of labour hire workers, it's worth turning your mind to what arrangements you have with this labour hire provider if an application is made.
Yeah, okay, great. Great. Well, it's just more complications, but yeah, I mean, it's great, great advice, Claire. So probably just put a question to both of you. You know, are there any other issues from an employment or tax? I mean, I know there will be, but you know, we've only got a certain amount of time to cover off, and we could speak all day. Any other issues that you think, you know, particular issues for a board that you want to raise? Perhaps to Anthony. I'll throw it to Anthony.
Yeah, thanks, Carl. So I think, look, one of the key messages from a tax perspective is, and for boards in particular, is to make sure you've got up-to-date and consistent payroll tax systems across your workforce. One example where problems can arise is for those businesses that are acquisitive and they buy new businesses, and there's a period often where the legacy payroll system that's been used by the business that was acquired just simply gets rolled forward under the acquirer's watch. Now, often it's going to take time to integrate those new businesses within the acquirer's systems and processes. And unfortunately, that sometimes gives rise to these ticking time bombs with the legacy systems, you know, for things like unpaid super and maybe even incorrect applications of EBAs and awards, which is not my area, but clearly it's an example of where, you know, we do have these legacy systems that can have these, you know, problems embedded in them. And so boards, I think, need to have some sort of processes in place that integrate these new acquisitions on a timely manner, and ideally have a single payroll system across their workforce.
Yeah, I mean, it's so important. I mean, I think just generally in the aged care sector, given how complex it's become, especially with the proposed reforms to the Aged Care Act, and all the reforms to employment law and dealing with tax issues, that we're going to see a lot of consolidation and merger and acquisition activity. And so we're going to have the coming together of workforces and having to deal with that. Claire, any other employment issues you'd like to touch upon?
I think in terms of what boards need to do, it's sort of a three-step of three pretty big steps, but a three-step process. One is understand what you need to do. So speak to lawyers or speak to your advisors and understand what are the changes and what do I need to do to be compliant with those changes. That's the first step. And if you're just asking this question now, you're probably already a little bit on the back foot because most of these laws have already started. The second is once you understand what you need to do, you need to think, how do I do this? So what steps do I need to be put in place to be compliant with this and to be prepared in the event, for example, someone makes the same job, same pay application, or someone complains about being on a fixed term contract for too long. What am I doing? Do I have systems and audit systems in place to figure out if I'm already in breach? And then finally, implementing the steps you decide upon in step 2. You know, putting all those actions in place to make sure you are compliant and remain compliant, and you treat it as an organic step. It keeps evolving, you keep it up to date, you keep checking in and making sure you are compliant with the laws.
Oh, great. Claire, that's very useful advice for boards, and yeah, I agree. If they have not been onto this already in like the previous 6 months, I mean, they better. It's one of those things that they
get a wriggle on.
They need to get a wriggle on. Anyway, well, thanks, Anthony. Thank you, Claire, and thanks everyone for listening today. As always, please get in touch. The best way to get in touch with either Anthony or Claire is via the Hall & Wilcox website. We hope you have enjoyed this series of podcasts that we've brought to you focusing on the aged care sector, and thanks for listening. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.